Hi folks, you're with Tacitus today at your Pushback channel, and thank you for joining this live stream. In this essay, I'd like to talk about the legal system and mentioning also the Kyle Rittenhouse trial, and look collectively at how the justice system has been corrupted and perverted from just about every direction. Now, for those who haven't been watching, I think most of you have, in the Rittenhouse case, the jury has deliberated for a second day. Again, surprising because the case, certainly in my view, was about as clear-cut self-defence as you can possibly get. So if it takes a jury 2 days and they still can't reach a verdict, there's got to be maybe some holdouts. But the more likely reason is they're terrified of coming back with an acquittal, and their strategy or tactics may be just to sit it out until the judge says, look, you can't reach a verdict, you can all go home, we'll have another trial, or we'll have a mistrial or whatever. But the longer the jury deliberates, and the more time goes by and other events in the news intervene, the more the crowd that's gathered out there expecting an imminent decision, the more they're going to drift off and go about their business and attend to other matters and so on. So it could be in a way a sort of a diffusion strategy, but nonetheless, the jury's job is to fearlessly produce a verdict, and it is the state's job to vigorously pursue any who would attempt to interfere or tamper with the jury, whether it be indirect or direct, or to make threats that they're going to come around and deal with the jurors later. Anything like that must be dealt with severely, I believe, by the state, and of course the state. I like the way they call Mr. Rittenhouse a vigilante. What do you think they're doing to James O'Keefe? What do you think they're doing to parents to school board meetings? Is that not state vigilantism? I mean, for goodness sakes, the hypocrisy of these people is mind-boggling. But in my view, people that intimidate the jury should be arrested and brought before an impartial, independent court of law, and then the evidence produced. And if they have engaged in intimidation or tampering, in the event they're trying to encourage or coerce a legal outcome that suits their personal preferences, and there's evidence to support that in an independent court of law, then they should suffer the penalties as prescribed under law, and that's the appropriate way to deal with these matters. Just coming back to the law being under assault from all sides. Now, I invite listeners to go and look at pretty much any college course for law. Now, you'll struggle through most of that course to separate. You'll be looking at what you think's a law course, or what you're told is a law course, and you'll be staggered at how much of it looks like it's come straight out of the gender studies department or the African American studies department. It's incredibly ideological, and not simply suggests, as on critical race theory type lines. It effectively exhorts lawyers to become activists and to pursue ideological social justice goals, and using the law to do it. Now, the methodologies here are generally this, and I'm giving them in sort of general overview terms. But if straight white males must meet a very high burden of proof, so they need to meet an extremely high burden of proof. But anyone of another race or minority that brings a complaint against them or is in legal contest with them, with the white folks, they have to meet a much lower burden of proof. So that these kids are being taught is going to produce an outcome of equity rather than rather than law or facts or evidence, which they're asserting is justice or social justice. And that's how they want to, or that's how they see the world, and they believe the justice system is a pivotal component, a pivotal device in bringing about the world of social justice that these ideological idiots imagine, or would like to imagine. It's sort of some weird Marxist utopia, and they think that by punishing straight white people and by giving free passes to minorities, that somehow it'll all end up as equity in the end. They don't really know how, but they just believe and have been told that this is the way to get there. And this involves various other devices that they're taught, effectively used, that there's evidence. If there's evidence there that may harm the interests of the minority, well, do you really have to bring it forward? I mean, if no one else knows about it, why don't you just sort of, put it in your top drawer and just not say anything to anybody? Well, why don't you do that? And it's likely that when the people who did the law course that you're doing are also going to be in the prosecutor's office. So you're a legal aid lawyer in the prosecutor's office. You guys get together, have an informal chat, and you just agree that you're not going to produce this evidence. You're just going to keep it quiet. I mean, the jury doesn't need to know. The judge doesn't need to know. In many of the cases, the judge will be on side. You can have a quiet word with the judge, and the judge, yeah, okay, no, that's fine. And you see this in the particularly ideological courts, ones that have been along the ideological beltway for quite a while, such as rape courts, divorce courts, all these sorts of things. And so the training that they're getting is that really perjury is okay. Conspiracy to commit perjury, well, if it's in a good cause, social justice, then why not? That straight white guy there, his great grandfather may have owned slaves. So, we should treat him like shit because morally he deserves it. So there are all these attitudes that are being pushed and are prevailing in so many law courses, maybe not all of them, but certainly in the ones that I'm aware of. Now, on top of that, in order to get more minorities into practicing law, they've lowered the bar and lowered the bar and lowered the bar. Now, years ago, certainly when I first started dealing with lawyers as a I don't know, I was probably in my early mid-20s, maybe. Excuse me. And I certainly the lawyers I met were very bright. They were certainly amongst the brightest in the community. The standards of getting into to study law were pretty high, so they were a bunch of bright people, and certainly the ones that I came across who believed in justice as achieved through facts and through evidence. Now, justice, they thought, was making sure that people like minorities got representation, that because the minorities maybe not as well educated or not as literate or not as aware of the law, that there was somebody who could advise them on the law and represent them, whether in exchange of snotty letters or something or in court. So that was a perception of how justice would be achieved, making sure that these disadvantaged people had representation, which seems fair enough to me. And the government, legal aid and that sort of thing, the government was putting money towards that, and I think that was good. I was in full support of that, and I thought it was a good cause and a sensible expenditure of money. But times changed, that it was no longer that these minorities had representation. That wasn't it. It was they had to win. And they had to win against the straight white male, and that was it. So the scales had to be tilted, and I've seen this directly in court proceedings, a number of them, by the way, including even petty sessions courts where, say, there are neighbours having a dispute over something or other. The judge, a junior judge, like it's not a big case. the junior judge will say, well, you look like you got plenty of money, Mr. Smith. Why didn't you just pay Mr. Jones when he wanted it or asked for it? That's an outrageous. Even the evidence doesn't support it. Why would? But that's sort of how the activists are going there. And really, anyone who was born sort of after, say, 1967, 68, somewhere around there, 69, and and anyone who's born sort of around that time or after has probably studied law when this social justice crap began to permeate the legal courses. And of course now it's a crescendo in terms of what's studied. So we've got lower IQ people. The bar's been lowered and lowered just to get to minorities. We've got lower IQ people who believe this crap. They believe that if you hide evidence that doesn't suit the minority, you've somehow performed a social justice public service. And they've got no idea of the wider consequence of what they're doing. Now, there's some older people that should know better. If you say for example, Merrick Garland, the Attorney General in the federal United States administration, he's old enough to have done his legal studies before this activism took place. Maybe he was in this, the Vietnam marches or something, but the idea of the law as facts and evidence and that sort of thing, that he was trained or did his law course during that time. So somehow he's been flipped from believing in evidence and facts into believing that social justice ideology is the issue, which, by the way, many Jewish lawyers did. So I guess it's somewhat consistent there. But that's how the law's under assault from the universities and the colleges, and also from law societies. Some of the, I ran through the names of some law societies around, and they're packed with activists who are there to again use the law as a device to bring about social change, or as they would see it, social justice. Now, they're keen for the straight white males to be subject to social justice, but not them. The straight white males who are on the packed into these law societies and things like that. They don't want to suffer. No, they're not going to give up their jobs for the black lesbian or give up their money. They still want to live in the waterfront properties and that sort of stuff, and drive Maseratis and the like. They still want that, but it's the other people who can get it. And they believe themselves to be a morally superior class. On what basis, I don't know. Anyone that agrees with conspiracy to commit perjury in a court of law surely has no moral standing whatsoever. But there you go. So it's under assault from all societies and all the colleges, the law, but it's also under assault from the media coverage. The media is just formed like a howling, and they're owned by the globalists. So they'll support pro-globalist positions and condemn those that don't suit the globalists. Mr. Rittenhouse, unfortunately, his situation just doesn't suit the globalist narrative, so they're going to determine to get him no matter what, or so it seems. So, and if you look at the quality of, say, the Attorney General in Kenosha, in Wisconsin, the one prosecuting the trial of Mr. Rittenhouse, in my opinion, he's nothing other than a two-bit sleazebag activist, in my view, and has no business practicing law. He's not prepared to deal with the facts. He's making up some absolute nonsense, some ideological mirage, and is refusing to engage with the facts. And by the way, if he did engage directly with the facts and the facts and the evidence in the case, then he wouldn't have brought the charges in the first place. So that the charges are political, and indeed the political ideology of just the summing up alone would give that away. Plus the line of questioning and the direction of questioning that was employed. So the law is under attack from pretty much all sides. Or the law, as we once knew it, of being facts, evidence, and due legal process, rules of evidence, and so on. Now, this took many hundreds of years to develop, with ups and downs and sidesteps and that sort of thing. just the writ of habeas corpus, that the government just can't throw you in prison without charges, without you having a right to be heard in a court of law. Just things like that. That took many hundreds of years. The power of the state very reluctantly gives up these arbitrary powers that they have, and or had, and habeas corpus, and went through a number of iterations. Habeas corpus is one of those. And if you recall, during the American Civil War, Abraham Lincoln effectively suspended habeas corpus, so people could be arbitrarily arrested and held in detention without formal charges being brought or indeed heard in a court of law. So now Lincoln thought he was, locking up agitators and locking up people that would inflame the already tense Civil War situation. That was his view. Nonetheless, I would argue now that that's not the way to go about it. It's not acceptable. If these people had committed crimes under law, then they should be brought before a court, that evidence produced, and they should be heard in court. And if the evidence led to it, and if they were found guilty, then they could suffer the appropriate penalties in an independent court of law that is not subject to any political coercion. There's the next thing I'd like to talk about is how, if you look at sort of any legal case or hearing that goes on in the United States and sometimes elsewhere in the world, the commentary is, oh, that was an Obama-appointed judge, or that was a Trump-appointed judge, or that was a Bush-appointed judge, or something like that. But the view is in the media, and many commentators, by the way, generally, is that Democrats will appoint radical, strident activists into positions on the bench, on the judges in the court, and the Republicans will appoint non-activists into the and therefore Republican appointed judge. Well, they're no good. They won't produce a verdict to support the black lesbian. And then on the other side, the Obama appointed judge is going to be a radical activist, which, by the way, many of them seem to be. But the issue here is the law. The law is not some fucking toy. It's not some toy to be played with as if it suits some political wind of the moment or some whim. That's not how it is. Hundreds upon hundreds, thousands of years have gone into producing the legal system. That is it 100% perfect? Of course not. But as long as the people are equal before the law and have full due legal process, the rules of evidence, and that they're, assuming they're represented, of course, and those facts, the evidence are heard in a court of law and beyond reasonable doubt, innocent till proven guilty, and so on, then that's the best we've ever got to, the best we've ever got. Now, the idea that this system somehow holds down minorities or elevates straight white males or something is nonsense. The facts in an independent court, if there's any political coercion or intimidation going on, or conspiracy to commit perjury or things like that, then that has to be dealt with. But the idea is that we probably achieved the best that humankind has ever achieved, and now we're tearing it all to pieces, and it seems to be something that people like or want, that the law is some toy to change society. No, it's not. No, it's not. And if you just treat the law as a toy and just kick it around and use it as a political fucking football, then one day that law that's been so trashed and so cut up and so beat up that it's almost not functioning at all, other than an ideological weapon against the citizenry, then one day you might cheer it on, but one day that law is going to come after you, and you're going to go, no, that's all my legal rights and my due legal process, the evidence and so on. And then no one's going to give a shit. They're going to, you're going to prison, buddy, and that's it. So that's the law under assault. And do we really want a situation where we look at every judge along the lines of, are they an activist, or how much of an activist, or will they bother to look at the facts? Or do they care about the facts? Do they only care about ideology? And all sides of politics, or both sides, all sides of politics need to take the view, scrupulously look at every judicial candidate and say, you must be completely independent. Even the merest whiff of activism, the merest whiff. And it doesn't matter what the activism for. It could be placard waving about anything. It doesn't matter. The merest whiff of activism, and you're not going to sit on the bench. Your job is to administer the law and the Constitution based on the facts and the evidence. If there isn't enough facts to put someone in prison, or to convict them rather, and thus they go in prison, then that's it. They're not convicted. Now there was sort of in the British system as it developed, the idea was that it's better that guilty people go free rather than the innocent be imprisoned. That's sort of a bit of a hangover from the time when they believed that the soul was immortal, but nonetheless, now that's reversed. Now, the activists openly say, well, it's better that a whole bunch of innocent people go to prison, provided we get the one person we don't like, such as the venomous fantasies and the vapors that go through their mind that they apply. And there are no doubt in my mind, there are judges and judicial officers, activists who believe that. Now, some years ago, I dealt with, I was talking to a lady. It was I can't remember if she's a prosecutor or just a lawyer that represented alleged rape victims, and she was certainly an activist and very focused on, very keen to put this way. She believed that one of every two men was a rapist. Also subscribed to the feminist thing of where any even consensual intimate relations is rape. It's like a form of second-degree rape in their view, because it involves penetration. It is thus an act of oppression and thus is a form of rape. And that's the mad logic. Again, this shit gets taught in legal studies in university. Again, you have a look at some of these legal studies courses. You'd swear it was a gender studies course. So I was talking to her, and she was talking about how, I remember she thinks one in every two men are rapists. She was talking about how she knows if someone's a rapist just as soon as she meets them, within seconds of the interview, or seeing them on video, for example. So she claims that she knows this, which is a bit of a stretch, I think. But anyway, that was her view, and really the trial or the case was kind of, well, why are we even bothering with this? And this was her take on things. I have to go through the process because the law requires it, but I don't know why. And I remember she's a lawyer, for fuck's sake. So her view is that she can tell if they're guilty within seconds. She knows she's got some sort of magical wand where she just knows if they're guilty or not. And she thinks that a trial is just an absolute waste of time. Now, she hopes for certain judges who are activists, and she hopes for the lawyer representing the accused to also be sympathetic to the, if you like, the cabal that runs the rape industry courts. And she was saying, well, get these guys locked up. Now, her view is that the bar of evidence should be very low for anyone who levels an accusation, because in her view, women never tell lies. The guy who's been accused should have a high bar of evidence to meet. So he's got to effectively prove that he wasn't alive or something at the time. Now, if you look at that, that's not dissimilar to how the way they're slanting the evidence against Mr. Rittenhouse, by the way. The bar of evidence that the district attorney suggests he should have to meet, not that he is that he didn't do it and he wasn't there. And if he wasn't there, and if he didn't have a rifle, and if he wasn't alive, if he'd never been born, then it never been happened. Therefore, it's still his fault. So that's the line they're taking there, which is a classic line device that they use in, say, the divorce courts and things like that, but also the rape courts. Now, I sort of complained about this, that innocent people could theoretically, at least, in fact, it's likely in the way this woman was talking, this lawyer, that innocent men would go to prison. And she just shrugged her shoulders. Well, hey, who cares? If a few innocent people sort of go to prison, it doesn't matter because we nailed a bad guy. Now, given that the he said, she said sort of, which is most of the rape sort of accusations. It's very rare. Very rare. It happens, but it's very rare that it's ever with violence or threat of violence. Um, so the the rate of successful prosecutions isn't that high because there's no evidence. And without evidence, now her view is, who cares? The allegation's been made. Who gives a fuck about evidence? Just lock the guy up, for goodness sakes. Now I said this is crazy. I mean, I said said to her, you're crazy. You're mad. This is insane. This is not due legal process or rules of evidence, or that people aren't being treated equally. One person has to meet a higher burden of proof than the other, and that's. And she looked at me. She said, I don't know why you care about it. You're not the sort of person who rapes women. I know that. So why do you care? You'll never have to go to court. I said, no, it's not about me, and it's not a personal issue. It's about the law and how the law is applied, and it must be applied evenly, and it must be applied in again, rules of evidence and due legal process. And she shook her head in disbelief. And said, well, if we do that, we'd hardly convict anybody. And then that's how it is. You must apply the law. But she saw it as an ideological social justice crusade. The law was just some inconvenience bullshit that she had to go through. But she saw it as a social justice crusade, and was quite. She said, well, why do you care about the people who are accused? Why do you care about the law? What do you care about this? And it's important. Now, this is a lawyer, by the way, and I'm arguing with a lawyer to say that the due legal process is important. And she was like, oh, you're crazy, fuck off. Like the law is just bullshit that gets in the way of me putting men in prison. But that sort of typifies, I believe, the sort of activist that's running around in the legal profession now, and there's many of them, and I would assert that they're in the majority now across the Western world, and I think it's the globalists want it this way because they can bring the whole system down, and so that we all lose confidence in it. Now, I want to have confidence in the law and judges and courts. I want to think that the courts are independent, or believe that the courts are independent. I want to believe that every lawyer is committed to representing their client fearlessly, but that's not how it is anymore. To whatever extent it was, it's certainly better previously, but now, if you look at the way the Federal Attorney General of the United States uses, and elsewhere, by the way, Merrick Garland's not unique. Elsewhere, the way the courts and the police and the FBI and the security services, the way they're used as globalist enforcers and crushers of all opposition to the globalist project, then you know how far the law's fallen. But it's in the globalist interest that we all lose confidence in the law and the system and in our institutions, because that allows them to put their globalist project in under the cover of a form of semi-anarchy. And I believe that's what they're up to. But we need to every politician and every citizen, we need to bring it back to bring the legal system back to a high standard, not IQ 70 minorities just being given free passes into law. That's bullshit. Then given jobs in the legal aid or something like that. That we need to have a situation where the lawyers are of the highest caliber intellectually. It's harder. Not that you can't, but it's much harder to fill high IQ mind with bullshit. Not impossible, just much harder. And then there'll be fewer activists running out. We've got to be scrupulous about appointing judges that are independent and non-activist. Absolutely scrupulous on that point. And there has to be, I believe, law societies and the like that are there to ensure that litigants receive equality under the law and equality in rules of evidence and due legal process. And we need we really need to do these things. And the quicker the better. You've been with Tastus today, your Pushback channel, and thank you for listening.